As a follow-up to a promise I made earlier this week, the City of Houston has revised its subpoenas, not withdrawn its subpoenas, but revised its subpoenas in the Houston Equal Rights Ordinance repeal petition case. The disputed request has been narrowed to focus solely on communications related to HERO and the petition gathering process. There is no mention whatsoever of sermons or anybody's feelings about homosexuality. This was always the intent of the subpoenas. I hasten to say that the lawyers on the other side knew what the intent was. They chose to spin this up into something it was not, but to be perfectly clear, we have revised the subpoenas. The original subpoenas were filed by pro bono attorneys, excellent attorneys, helping the city prepare for the January trial in this case, but they were too broad. They were typical attorney language in a discovery motion. They were asking for everything but the kitchen sink, and we're making sure exactly what we want to see. I support the right of the clergy to say whatever they want to say, even when I disagree with them. We don't need to intrude on matters of faith to have equal rights in Houston, and it was never the intention of the City of Houston to intrude on any matters of faith or to get between a pastor and their parishioners. This is about what they may or not be preaching from the pulpit. It is about proving that the petition gathering process organized by these pastors did not meet the requirements of the city charter. And remember, they sued the city. This is part of our response. The information we have requested is critical to proving the city's contention that the petition was ineligible for placement on the ballot, and that the organizers knew this throughout the petition process. As before, and this has not changed, the city is seeking information from just 5 pastors who were at the forefront of organizing the petition drive. Pastors Hernan Castano, Magda Hermida, Con Nguyen, Steve Riggle, and Dave Welch. The revised subpoenas now call for all speeches or presentations related to HERO or the petition prepared by, delivered by, revised by, or approved by them or in their possession. According to the city charter, a valid petition must contain enough signatures of registered voters to at least equal 10% of the total votes cast in the last mayoral election. Each signature must be accompanied by the printed name, address, voter registration number or date of birth, and the date signed. Anyone who collected signatures must also have personally signed the petition and have appeared before a notary to acknowledge under oath that the signatures were made in their presence. Language right out of the city charter. Not changed for this petition process, not in any way amended by council, the city attorney, or by me, right out of the existing charter, and has the same language has been applied in previous repeal petitions. Thousands of signatures submitted with the HERO petition failed to meet one or more of these requirements and had to be disregarded under our charter. As a result, the petition could not be placed before voters. HERO opponents file suit against the city in an effort to reverse this decision and force the issue onto the ballot. The case is set for trial in January. The revised subpoenas that we are issuing today may be further revised. As I understand it, the city attorney is here with me. The attorneys on the other side objected to a number of requests for documents, and we have an opportunity to respond, but we're moving ahead with this because of the media interest, but this is part of the normal give and take of any lawsuit in play. Do you have questions?
Yeah, Mayor, the phrasing here, the new phrasing that all speeches or presentations related to HERO or the petition, in theory that could still include the sermons that got everyone so exercised about this.
It's what we're trying to get to is the instructions for filling out the petition. That's the whole crux of the lawsuit. That's what we need.
But this wouldn't necessarily rule out the gathering of those.
This is not about what anyone is preaching. This is not about their religion. It's not about the free exercise of religion. It is our right to defend the city and asking legitimate questions about the petition process.
Mayor, why doesn't it just say that then?
It does.
It's a little
Read the
bit
petition.
more- It's a little,
I mean, no, I think it's pretty clear. It says, communications related to HERO, the petition gathering process, you have the exact wording. All speeches or presentations related to HERO or the petition prepared by, delivered by, revised by, or approved by. We don't want their sermons. We want the instructions on the petition process. That's always what we wanted, and again, they knew that's what we wanted because that's the subject of the lawsuit.
Mayor, do you think you would have bothered to change the language had it not for the attention?
No, we wouldn't have, because the subpoenas are still in place. They knew what we wanted. This required a little extra work on our part to clarify the language, but the language could have been clearer at the beginning. Obviously, I didn't review the language before it goes out. I don't read those kinds of legal documents in detail. And we have excellent pro bono representation, and we trust them to carry on, and there's nothing inappropriate with their request, but it was worded in a way that allowed misinterpretation. This clarifies it, focuses it back where it needed to be. But no, we wouldn't have weighed in if it hadn't been brought to our attention.
Can I make a comment about that, Larry? In the normal discovery process, as any trial lawyer knows, if the other side has a problem with your discovery request, before you file a motion to quash, you're supposed to confer about the issue. Now, had they done that in this case, and they never did, they just went off and filed a motion to quash and then got the media involved, they could have told us that they had an issue with this request, and we would have agreed. But they decided to make it a media circus.
I realize that much of what's gone on is part of a pretty standard legal process, but, this is a controversial issue to start with. It's always been controversial. You guys knew going into defending the lawsuit it would have been controversial. Do you think the attorneys involved and people involved should have paid closer attention knowing just how controversial and sensitive the issue is?
Probably.
I mean, is it something that?
But again, we appreciate the fact that law firms in the city of Houston were willing to offer their services pro bono, that actually many of the big law firms in the city were supportive of the Houston Equal Rights Ordinance, believe it's the appropriate thing to do, and that this particular prominent law firm, Sussman Godfrey, was willing to offer its pro bono services, and they're not in the media fishbowl the way the city attorney is. But
And let me add, Mayor, the members of the legal department also saw these requests. I did not. Lawyers, as typically, don't have that kind of political sensitivity. After 4.5 years, I finally do. So maybe. I would have done it differently. We recognize that now. But I also want to point out again that it's very common, as the mayor pointed out, for lawyers to ask for a lot of things and then agree with the other side to pare down their request. That could have happened here.
But they raise a legitimate issue. The language is too broad. As I said on Wednesday, I didn't find out about it until Tuesday night, and actually I didn't find out about it, and I don't think the city attorney found out about it until the lawyers for the other side, they didn't bother to talk to us. They just had a press conference, and I found out about it through Twitter, I believe. And the very next day, first opportunity, we said the language was too broad, we would address it. We have now refiled that particular segment to clarify exactly what we meant, and we're moving on.
You mentioned that it is a legitimate issue, that say to someone with concern that the current wording, even though you're saying it's not the intent to get sermons, it does not preclude the gathering of sermons in response to the request?
Well, if during the course of the sermon, and I doubt this very much, but a pastor took 15 or 20 minutes to go into detail about how the petition process goes, then that's part of the discovery. But that's not about preaching a sermon on, anybody's religious beliefs. It's not conveying a religious message. That's part of the petition process, and all we're interested in is the petition process.
I think we're good.
So.
Mayor,